Swayam Prabha. Digital India. Educated India.
In the case of a dispute involving scientific or technical issues, a panel should seek advice from experts chosen by the panel in consultation with the parties to the dispute. So, after seeking the required approval, or let's say advice from the parties that are the stakeholders here, the expert opinion of the panel can be chosen. Panel in consultation with the parties to the dispute, the panel may also, when it deems it appropriate, establish an advisory technical experts group or consult the relevant international organizations at the request of either party to dispute or on its own initiative. So further, in addition to what the experts are chosen, what else can be done after the experts chosen, that they can further seek opinion at the request of the either party, that is either of the stakeholder or of their own, the advisory technical expert group. So they may, let's say, if something seems to be out of their reach, or they want further, let's say, supportive data, or they want further supportive evidences which probably might be more helpful for them to reach any conclusion, so they are also permitted to do under this section. So article 11 in that respect is very relevant for not simply resolving the disputes or resolving disagreements concerning sanitary and phytosanitary measure, but also enables the relevant persons, mainly the dispute resolving persons, to seek expert opinion from expert bodies and the subject experts. It appropriate establish an advisory technical expert group or consult the relevant international organizations at the request of either party to the dispute or its own initiative. Members also have the right to seek settlement to dispute through other international organizations or dispute mechanisms established under any other international agreement. So if the members, because the member states, they may in certain cases adopt the sanitary and phytosanitary rules or the standards according to their own, let's say, choices from different international organizations that usually are working independently, and that may create an independent set of standards. So how the member will resolve the dispute in such cases, whether they should follow the dispute settlement body of the WTO, the procedure that is devised by the dispute settlement body of the WTO, or the consultation process that is through the dispute settlement body, or they can take the alternative measures through the international organizations from where they have taken those standards, or the data, the source of the data they have used for setting their own standards in terms of sanitary and phytosanitary measures. So that kind of option is also available under Article 11 to the parties. Implementation. Article 13 of the Sanitary and Phytosanitary Measure Agreement talks about the implementation, that is after the decision has been given or after the parties have reached to the point of consensus during the consultation process or after the result of the consultation process. So implementation, national governments are fully responsible for observance of obligations under this agreement. So primarily, as you know, for all the WTO agreements, there is a general rule that the member states, they are supposed to accept the observations that are made, and also the obligations that are set by the particular agreement. So here, when talking about the sanitary and phytosanitary measure agreement, whatever are the aims and objectives of this agreement that are binding, or the member states, they are responsible for its observance and its compliance. To assure this level of responsibility, national government must formulate and implement positive measures and mechanisms to support the observance of the provisions of the agreement by other than the central government bodies. Now the question arises, it's theoretically easy to say that after the member states they have ratified the WTO treaty, or they have signed the WTO agreement, obtained the membership, but then how they will practically implement the measures. So those measures can be implemented if they set the legal structure in that order. That means they have to formulate the legal structure that is creating the roadmap for meeting the WTO objectives, or they create the legal structure that helps them to fulfill the objectives. Or if not simply the legal structure, sometimes they have to enact a new law that is in support of the objectives or the obligations that are set by the WTO. So here, whatever are the objectives set by the sanitary and phytosanitary measure, that can be fulfilled or that can be realized by the member states if they have the corresponding law in their domestic system, and also the legal system that is going to support it through the implementation process or implementation methods. So that kind of work is required when we talk about the implementation. To assure this level of responsibility, national government must formulate and implement positive measures and mechanisms to support the observance of the provisions of the agreement by other than the central government. The first is the law is enacted by the central government. This is in case of the federal structure. Then how about its implementation up till the regional level, or even up till the local level? So that means that requires the enabling laws or the connecting laws to implement it up till the local level. That means people in the rural areas are also aware about what it means by the standards as set under the sanitary and phytosanitary measures. Now that's a big task, because the level of technical expertise that is required under this agreement, and then the level of legal implementation that is required requires the government or of the member state to put more effort. Mechanisms to support the observance of the provisions of the agreement by other than the central government bodies. This include local, regional and provincial governments, semi-government, private sector organizations, commissions, committees or institutions, non-governmental organization, any other organization with or without official sanction or recognition. Now, I would like to add here that the educational institutions, they can also play a vital role. Educational institutions here means the law teaching institutions. They must make people aware about this sanitary and phytosanitary measures, the standards, and how those standards are implemented while there is a trade between different nations, and mainly the trades in relation to the food products, and there are chances of the health risk. So that simply the task cannot be simply expected from the lawmaking bodies or the bodies at the regional level, but if we are expecting something to happen even at the ground level, then definitely the law institutions must also be involved for spreading or disseminating the information about sanitary and phytosanitary measures. Article 14, that is the final provisions. Final provision of this agreement allows the less developed country members to delay application of the provisions of this agreement for a period of 5 years following its date of entry into force, with respect to their sanitary or phytosanitary measure affecting importation or imported products. Now, as stated earlier, that when we were discussing special and differential treatment, so there also the more flexibility was talked about, but that was concerning both the developing countries and the less developed countries. So here more emphasis is paid to the less developed countries, because the extent of changes which is required in their system, and the level of scientific and technological know-how that we do expect in fulfilling the objectives of sanitary and phytosanitary measure makes the task bigger for the less developed countries. Therefore, larger period or the time period has been extended for their compliance. Other developing country members may delay application of the provisions of this agreement other than paragraph 8 of Article 5, providing a member with information and an explanation as to the reasons for sanitary and phytosanitary measures. Now, if other members, other developing countries, they also want extension of time for fulfilling the, let's say, the requirements of this agreement or setting the standards, They may give the due explanation for their reasons of that delay or for extension of time. And Article 7, transparency, inquiry point and notification procedures, Annexure B, for 2 years following the date of entry into force of this agreement. So various sections, or let's say the various modules of this agreement, if we divide the different set of this agreement into different set of modules, depending upon different kind of responsibilities that are required by at the sub level, so different sub level can set different time frame for the developing countries, for the less developed countries. For 2 years following the date of entry into force of this agreement with respect to their existing sanitary and phytosanitary measure affecting importation or imported products which where such application is prevented by the lack of technical expertise, technical infrastructure or resources. So the general level of reasons why more time period is required is given here, where the application is prevented by the lack of technical expertise, that is the countries they have lack of technical resources or mainly the expert areas in that particular field, then technical infrastructure that is required, or the resources, that is the financial resources. I repeat this, other developing country members, that is in addition to what we have talked about the less developed countries, may delay application of the provisions of this agreement other than paragraph 8 of article 5, that is with regard to the implementation. And as to the reasons for sanitary and phytosanitary measures, and article 7 that deals with transparency, inquiry point and notification procedures, Annexure B. So for these two there is not much of the flexibility, but for the others there is a flexibility for 2 years that can be availed by the developing countries. For 2 years following the date of entry into force of this agreement with respect to their existing sanitary and phytosanitary measures affecting importation or imported products where such application is prevented by lack of technical expertise, technical infrastructure or resources. Now let's take the example that country A is a developing country. Here like country A is a developing country. Now it can seek 2 years extension. Extension for what reason? That is for the lack of technical expertise, technical infrastructure or resources. But this 2-year extension is not applicable for the article 5 paragraph 8, not applicable for not applicable for article 5 para 8 or and article 7. All right, that is like for transparency, inquiry point and notification procedures. So these things that are much more mandatory in nature, so therefore the developing countries they must abide by these basic regulations, but for the others the 2-year time period can be availed by them. Next is the entry into force. The date of sanitary and phytosanitary measure agreement was on 1st January 1995 when the WTO came into functioning. There are certain relevant cases that have been listed here for explanation regarding the practical functioning, how the sanitary and phytosanitary measure rules are applied. First is the case of European communities measures concerning meat and meat products, or it is termed as beef hormone case. Now here let me narrate firstly the brief facts, where the European Union put restrictions on the meat that is imported from United States. So European Union put restrictions on the meat and mainly the beef that is coming from United States, claiming that they are using some growth hormone which leads to some kind of biological disorder or that can create physical problem in the consumers with the consumers in the European Union. So they discarded or they put restrictions on any such meat and meat products that was coming from the United States. Now this was challenged by the United States before the dispute settlement body, that such restrictions imposed by the European Union is contrary to the sanitary and phytosanitary measure rules, because here the European Union has made the claims on the health ground, because it is the animal product, and these animal products contain hormones, growth hormones, and that for one or the other reason are health risk to the consumers in the European Union. So in retaliation to this, the United States claimed that such restrictions imposed by the European Union does not fulfill the requirements of sanitary and phytosanitary measures. So what is it? Measure at issue, European Community's prohibition on the placing on the market the importation of meat and meat products treated with certain hormones. Product at issue, meat and meat products treated with hormones for growth purposes. Now what was the panel's finding? Panel decided on 2nd July 1996. The panel was composed. The panel report was circulated to members on 18th August 1997. The panel found that European Community's ban on imports of meat and meat product from cattle treated with any of the 6 specific hormones for growth promotion purpose was inconsistent with Article 3.1, 5.1 and 5.5 of Sanitary and Phytosanitary Agreement. So here the panel was not ready to accept what the contention was raised by the European Community. Now what is Article 3.1? That is to harmonize sanitary and phytosanitary measures on as a wide basis as possible. The members shall base their sanitary or phytosanitary measures on international standards, guidelines or recommendations where they exist, except as otherwise provided for in this agreement and in particular paragraph 3. So basically the Article 3 talks about harmonization of the sanitary and phytosanitary rules among the member states to make it according to the international standard. Now here the question was whether European Union can have their own set of sanitary and phytosanitary standards for putting restrictions on the meat, or it is forced to abide by the standards that are based on international parameters. So here European Union has tried to set its own standards different than that of the international parameters, and this was one of the challenge before the panel body, where the panel found that this ban on the ground of Article 3.1 was inconsistent. Now the other provision that was challenged was Article 3.3, which covers that members may introduce or maintain sanitary or phytosanitary measure which results in a higher level of sanitary or phytosanitary measures protection than would be achieved by the measures based on relevant international standards, guidelines or recommendation if there is a scientific justification, or as a consequence of the level of sanitary or phytosanitary protection a member determined it to be the appropriate. Now as discussed that despite the fact that there are bodies, international bodies that try to set a uniform standards of rules for applying this restrictions, but that does not forbid a nation to not accept or not take their own standards which is higher than the international standard, and that is covered under Article 3.3 that allows the members to maintain a higher standard. So in this case the European Community has gone for the higher standard than whatever is the international standard, and which was challenged by the United States. Now on what basis the European Union has applied higher standard? That is based on the risks that the consumers from the European Community, when they will consume such meat, they will face various complications. Now what was the source of their information of this risk? So that risk cannot be some kind of fancy thinking or based on some artificial sources, or it can be simply out of imagination. It has to be supported by scientific evidences that for what reason they feel that there are chances of such risk. And here in that respect the assessment of risk and determination of the risk, that was not very substantive on the part of European Community. But what is here? Assessment of risk and determination of the appropriate level of sanitary or phytosanitary protection. Article 5.1, members shall ensure that their sanitary and phytosanitary measures are based on an assessment as appropriate to the circumstances of the risks to human, animal or plant life or health, taking into account the risk assessment techniques developed by relevant international organizations. So it cannot be simply the choice of the nation that they feel that there are chances of risk, but it has to be supported again by the scientific data, and all those scientific parameters that are being taken, they must be the recognized parameters by the international bodies. So what was the case here? The next is the other point of contention that was raised by the United States before the panel body, that was concerning Article 5.5 with the Article 5.5 of the sanitary and phytosanitary measure, with the objective of achieving consistency in the application of the concept of appropriate level of sanitary or phytosanitary protection against risk to human life or health or to animal and plant life or health. Each member shall avoid arbitrary or unjustifiable distinctions in the levels it consider it to be appropriate in different situations. Now, although the member states do have the choice to, they have different kind of choices. One is the choice to have their own standards other than that, higher than that of the international standard. Second choice they get while risk assessment, but then the risk assessment should be based on certain scientific data, and that scientific data must be based on internationally recognized parameters. And then the thirdly, they do have the choice with regard to the other risks, like with the objective of achieving consistency in the application of the concept of appropriate level of sanitary or phytosanitary protection against the risk to life or health or to the plant and health of each member shall avoid arbitrary and unjustifiable distinctions in the level it considers to be appropriate in different situations. So what if they consider that their situation is different than that of the other countries, that simply cannot be based on arbitrary or unjustifiable distinction. That has to be also supported by certain evidences that why they consider their situation different than that of the other countries, and based on that different in situation or circumstances, if they want different set of rules to be applied, then that has to be supported by evidence. If that is not the rule, then what will be the consequence? The member states, all the member states of the WTO, they will start claiming their situations are different than that of the other member states, so they need to apply the different set of rules. Now, how the dispute settlement body has reacted to this? Firstly, the matter was taken to the panel body, and after the decision given by the panel body, it was the conclusion drawn by the panel body, it was challenged before the appellate body. Now, what is for the appellate body to do here? It considers appropriate in different situations if such distinction result in discrimination or disguised restriction on international trade. Now, the appellate body upheld the panel's finding. The appellate body accepted the panel's finding, that is mainly the restrictions imposed by the European community with regard to the meat and meat products from the United States. That goes contrary to the provisions that are included in sanitary and phytosanitary measures, and mainly the provisions listed in Article 3.1, 5.1, 5.5, Article 3.3. So, but there is minor change which the appellate body has made here. The appellate body upheld the panel's finding that the European Community import prohibition was inconsistent with Article 5.1 of the Sanitary and Phytosanitary Agreement, but reversed the panel's finding that European Community import prohibition was inconsistent with Article 3.1. Article 3.1 that gives here is the Article 3.1 that gives, while making harmonization, members base their sanitary or phytosanitary measures on international standards, but where they think that they can have the higher level of, or the level different than that of the international standard, that is permissible. So that is not like breached by the European Community. Otherwise, with regard to the other articles or other provisions of the sanitary and phytosanitary measures, the appellate body accepted the decision given by the panel. The prohibition was inconsistent with 3.1 and 5.1 of the sanitary and phytosanitary measures. On the general and procedural issues, the appellate body upheld most of the findings and conclusions of the panel, except with the respect to the burden of proof in proceedings under sanitary and phytosanitary measure agreement. Next is another case of such nature where Australia has put restrictions on the salmon that is exported from Canada to Australia. Now, this is the case with regard to quarantine period, and there are not simply quarantine period, but some type of salmon they are not permitted to enter into Australian market, and even if they are permitted, that is like the living salmons, if they are permitted, then they should be quarantined for certain period of time, where the Australian authorities can verify whether they are totally free from infections or not. So how is it? On 5th October 1995, Canada sought consultation with Australia. On 10th April 1997, a panel was established at Canada's request. Now, what is the relationship between consultation procedure and panel? So initially it is the consultation procedure that is initiated. If the parties agree to the results or to the conclusions of the consultation procedure, then there is no reason to move ahead. So that means the parties have resolved the dispute at the consultation stage. But if either of the party is not willing to accept the decision given by the consultation, then that party who has not accepted or it does not go by that decision reached at the consultation stage can go for the judicial process, and that the first stage of judicial process starts with the panel stage. Now here, as it is mentioned that Canada sought consultation with Australia. On 10th April 1997, a panel was established at Canada's request. That means when they could not reach to the amicable solution, then they went for this panel body. A panel was established at Canada's request with the European communities, India, Norway and United States participating in the panel proceeding as the third parties. The panel report, which was circulated on 12th June 1998, was appealed by the Australia. So whatever the decisions were given by the panel body, that it seems that the panel body goes against the Australia's decision to put restrictions on the import of salmon and salmon products from Canada. The panel and appellate body reports were adopted by the dispute settlement body on 6th November 1998. The appellate body upheld the ruling. Now, as stated to you earlier, that if the decisions of the panel body are not accepted by the parties, the matter goes for the appeal, and appeal goes to the appellate body. So it seems like here also the matter was referred to the appellate body after the decision given by the panel body. So the appellate body upheld the ruling of the panel that Australia's ban on salmon imports was inconsistent with the agreement on sanitary and phytosanitary measures. In response to this decision in July 1999, EQOIS, that is Australian Quarantine and Inspection Service, as stated to earlier, that Australia has permitted only certain categories of salmon and salmon products entering into the Australian market from Canada. And even if the living salmon they were allowed to enter into the Australian market, they were first taken for the quarantine period. And with regard to this quarantine thing, Australian Quarantine and Inspection Service, a decision lifting the import ban on salmon but increasing the quarantine requirement for several species of fish in line with the risk assessment undertaken, was considered inconsistent. Now, what was the ground for Australia to ask the fish for quarantine? That was for knowing whether there is some risk involved or not, and that takes time. But the time period they take was quite long. On 28th July 1999, Canada challenged these new measures in the WTO and requested that the original panel consider its complaint that Australia had failed to comply with the rulings and recommendation of the WTO. Now, what was the case here? Basically, it was decided that Australia should withdraw its restrictions it has imposed on the salmon coming from Canada. It should reduce the quarantine period, but Australia has not fully complied with the decisions given by those bodies, the appellate bodies even. So when it has not fully complied, the matter was again raised, or it was challenged by the Canada before the WTO system. So on 28th July 1999, Canada challenged these new measures. Now then, what was the new measures? The new measures were the earlier quarantine period was extended by Australia, and it has partially waived off the restrictions that were imposed on the salmon and salmon products coming from Canada, but not totally waived off the restrictions that Australia has imposed. So in the light of these changes, the Canada has again challenged the matter before the panel body. So on 28th July 1999, Canada challenged these new measures in the WTO and requested that the original panel consider its complaint that Australia have failed to comply with the rulings and recommendations of the WTO. Canada also requested WTO authorization to retaliate against Australia for its non-compliance. So there is a provision that in case the parties or the member state does not comply with the decision given by the dispute settlement body, then the other party can retaliate. So there can be like trade embargo, or there can be other form of restriction imposed on such countries that do not comply with the decisions of the dispute settlement body. And same was requested by Canada here in this case, because Australia, although the decision was given by the appellate body, but Australia was not complying it fully. So as a matter of complaint, the Canada has asked the dispute settlement body to take certain non-compliance measures. The panel also found that Australia, by requiring that only salmon product that is consumer ready as specifically defined can be imported into Australia and released from quarantine, was maintaining sanitary measures that were inconsistent with sanitary and phytosanitary measure agreement. Now, what was the ground? Australia was putting restrictions. It was putting restrictions on the salmon because of the health reasons, and those health reasons were covered under the sanitary and phytosanitary measures. In reply to this, the Canada was contending that whatever requirements as set by Australia, they goes contrary to the sanitary and phytosanitary measures. So they are inconsistent with such measures. Therefore, what was the final decision? That Australia was forced to, or Australia had to accept these changes made by the panel body, and it has to accept the decision given by the panel body. Next is another very important case, that is measure concerning the importation of certain agriculture products. Now here it is the restrictions imposed by India on account of aviation flu. Now that is the bird flu, popularly known as the bird flu, and it has put restrictions on products coming from various countries, mainly the bird meat, and mainly here it is the case of the bird meat coming from United States, to which the United States has challenged. Measures concerning the importation of certain agriculture products complained by United States. The measure at issue are the Indian Livestock Importation Act 1898, Livestock Act, a number of orders issued by India's Department of Animal Husbandry, Dairying and Fisheries pursuant to Livestock Act, most recently SO number 1663 E in brackets, as well as any amendments related measures or implementing measures. These are the provisions that are being challenged, because India, according to these laws, have put restrictions on the imports of the bird meat from various countries, and one of them is United States. The United States claimed that the measure appeared to be inconsistent with Article 2.2, 2.3, 3.1, 5.1, 5.2, 5.56, 5.7, 6.1, 6.2, 7 and Annex B, paragraph 2, 5 and 6 of the Sanitary and Phytosanitary Measure Agreement. Now, whatever were the findings of the panel body, the matter was referred for appeal, and the appellate body has agreed to the panel's decision. The appellate body agreed with the panel that its finding that the India's aviation influenza, AI stands for aviation influenza, measures are inconsistent with Article 5.1, 5.2, because they are not based on risk assessment, because it was more like the general information that in many countries this aviation influenza is affecting the birds, and therefore restriction should be imposed on the meats, from the bird meat. Now, if there is a general information like such infection has taken place, or the birds are getting infected, but we cannot generalize it in that sense, that if this particular country, the birds of this particular country is facing this crisis, the same is the case with the birds from the different other countries also. So if we go by the general conclusions or the presumptions drawn based on these general observation, that may amount to inconsistencies with the Sanitary and Phytosanitary Measure Agreement, or that may amount to violation of the rules. So here, based on this general information, India has imposed the restriction to which the United States has challenged, that it is inconsistent with Article 5.1 and 5.2, because they are not based on risk assessment. Firstly, the Indian market, or let's say the Indian lawmakers, they should have gone by the scientific data, that what is the level of risk assessment if the meat, bird meat, is coming from United States. Because they are not based on a risk assessment. However, the appellate body found that by failing to consider whether such presumption had been rebutted by arguments and evidences presented by India to establish a scientific basis for its import prohibitions on fresh poultry, meat and egg from countries reporting low pathogenicity, AI, LPNAI, that is low pathogenicity notifiable aviation influenza. That means where the category of this infection is quite low and it's not at the risky level. The panel had, let's say, the panel erred in its application of Article 2.2. The appellate body thus reversed in part the panel's finding that India's aviation influenza measures are inconsistent with Article 2.2 insofar as those findings concerns India's import prohibitions on fresh poultry, meat and egg from countries reporting low pathogenic notifiable aviation influenza. The appellate body upheld the panel's finding under Article 3.2 that India's aviation influenza measures are neither based on nor conform to the relevant international standards. So, the risk factor, since that was not calculated wisely by India, neither that was supported by any international standard, therefore, India had to withdraw its restriction imposed. The appellate body also found that in applying Article 6.2 to determine whether India's aviation influenza measure recognized the concept of disease-free areas and areas of low disease prevalence in respect of aviation influenza, the panel did not err in taking account of both the instruments through which India maintains its import prohibitions. Now, what is required here and where there was another failure or let's say error on the part of the India's imposition of restriction, that even if there are such infections going on in particular country or in particular places, then still it can be notified that this infection or this let's say problem is confined to this particular region. We cannot simply make the product coming from that particular country, we cannot impose restriction on the products coming from that particular country altogether. So, if the products are coming from that particular area of the country which is infected or where there are symptoms of such infection, that is acceptable, but not restrictions being imposed on all the products coming from any part of that country. That is not what the sanitary and phytosanitary measures are about. So, it has classified that there are the states can make the declaration about the classification of areas where there is a low extent of infection, or the areas there which are totally free from those infections, through which India maintains its import prohibitions, the Livestock Act as amended and SO 1663, rather than relying on the parent legislation alone. So, here the India should have, as it is mentioned, that they should have taken into consideration the amended part on the Livestock Amendment Act rather than going by the parent act, where such provisions are not included to exclude the restrictions or to create exemptions on the restrictions being imposed depending upon which area is infected and which area is not infected. The appellate body endorsed the panel's finding that India's aviation influenza measure violate Article 6 because they require the prohibitions of all imports from any country that has notified aviation influenza to the OIE, and thus foreclose the possibility of allowing imports from aviation influenza free areas within such countries. For these reasons, and after also rejecting claims raised by India under Article 11 of the Dispute Settlement Understanding, the appellate body upheld the panel's finding that India's aviation influenza measure are inconsistent with Article 6.1 and 6.2 of Sanitary and Phytosanitary Measure Agreement. In addressing India's claim that the panel erred in its application of Article 5.6 to India's aviation influenza measure, the appellate body found that panel did not err in finding that the United States had identified alternative measures that would achieve India's appropriate level of protection, and that the panel did not fail to identify the alternative measures with precision. So, going back to the debate here again, that primarily it is in case the country faces these problems or country is expecting that the restriction should be imposed. So, better is to start with consultation firstly, that if the consultations are initiated, then it will be convenient for a country to know whether from what which part of that particular country the products are being exported, or what is the area where this infection is going on. So that will make things more clear. Instead of unilaterally imposing restrictions on the product from that particular country or from anywhere that products are coming, that may amount to the violation of the rules, or that can be the arbitrary application of the restrictions. After also rejecting claims raised by India under Article 11 of the Dispute Settlement Understanding, the appellate body upheld the panel's finding that India's aviation influenza measures are inconsistent with Article 5.6 because they are significantly more trade restrictive than required to achieve India's appropriate level of protection. Because India took this risk factor into consideration, but what was the scientific basis of that risk factor? With respect to the products covered by Chapter 10.4 of OIE Terrestrial Code, and found it unnecessary to address panel's finding under Article 2.2. Now, with this, we have almost finished sanitary and phytosanitary measure agreement, but now there is a similar such agreement of larger scale, but with larger scale, that is agreement on technical barriers to trade. So we start with this new agreement, that is agreement on technical barriers to trade. While initiating the discussion on agreement on technical barriers to trade, one thing I would like to suggest at its outset, that many times this may seem that it is there are some areas overlapping with that of the sanitary and phytosanitary measures, because both the agreements, their purpose is to maintain the health thing, and in case of the technical barrier to trade, it is not only confined to the health thing, but it's also covered the national security aspect. And the technical barriers to trade is not only confined to the food items, but it covers the wide items like the sales of the goods also is included in this part. But there are some areas where you may find quite similar aspects with that of the sanitary and phytosanitary measures. So how this agreement was introduced? This agreement will extend and clarify the agreement on technical barriers to trade reached in Tokyo round. It seeks to ensure that technical negotiations and standards, as well as testing and certification procedures, do not create unnecessary obstacles to trade. The first is that we cannot ignore technical barriers. Technical barriers includes like safety measures that can include breaching anyone's privacy. So there are a wide array of things, or the protection of trademarks, whether the trademarks fall within the ambit of technical permissibility or not, and that requires approval, and that approval is based on testing, based on the procedures that are accepted. So first is the procedures, based on the procedure testing, after testing the approvals and the certification. So all that is covered under this technical barriers to trade. Now how this works, that is all based on the rules. So the rules govern all the procedures with regard to testing, certification, and the related areas. But why it's based on the rules? So that unnecessary obstacles are not created to the trade. Like if the country A, let's say, has started exporting too much of goods to country B, so the goods cannot be restricted on the ground that it's threat to national security. Now what is the national security? Although the restrictions can be imposed based on the national security, but what basically is the national security, that is again to be defined according to the rules as set by the technical barriers to trade. So that is where these the rules, they take things under their regulation to draw the rightful distinction between what kind of restrictions are required, and not simply what kind of restrictions are required, but also the proportionate level of restrictions that are supposed to be imposed when these goods are traded from one country to another country. However, it recognizes that countries have the right to establish protection at levels they consider appropriate, for example, human, animal, or plant life or health, or the environment, and should not be prevented from taking measures necessary to ensure those levels of protection are met. So firstly, it sets the kind of protection that are required, and then the level of protection. The level of protection very much depends upon the proportionate level of restrictions. So they both goes alongside, because if we say we need 100% protection, so there can be no trade across the countries, but we have to take the risk factor also into consideration, and to what extent those risks can be covered. The agreement therefore encourages countries to use international standards where these are appropriate, but it does not require them to change their level of protection as a result of standardization. So every country has its own challenges and every country has its own security consideration. So although despite these different challenges and different security consideration, there is some general, let's say, requirements, or let's say the general yardsticks for putting restrictions on the ground of national security or for meeting those challenges, and that general ground has to be accepted, although in certain exceptional cases only those standards above those general grounds can be imposed or can be requested for. Now, what else? Innovative features of the revised agreement are that it covers processing and production methods. Now, it's not simply confined to the trade in goods, but it also covers the other features. Like innovative features of the revised agreement are that it covers processing, what process has been adopted for manufacturing that particular good or for producing that particular good. Processing and production methods related to characteristics of the product, because that may be defining point of the true characteristics of the final product. For example, let's say something that is made out of a hazardous substance. Whatever is the final outcome, that definitely will be more risky to the health of the human being, to the safety and security of the human being. But if like the same product can be manufactured without the use of inputs that are hazardous by one way or the other, or by replacing that hazardous input, that definitely the final result will be less risky. So in that respect, the comparison is drawn with regard to not simply the final product, but also the process that is adopted while producing that product. The coverage of conformity assessment procedures is enlarged and the disciplines made more precise. Desiring therefore to encourage the development of such international standards and conformity assessment standards. So relying on the international standards of safety and security and conformity with those assessment systems, like to what extent the process of manufacturing the goods are in conformity with those international standards. Desiring, however, to ensure that technical regulations and standards, including packaging, marking and labeling requirements and procedures for assessment of conformity with technical regulations and standard, do not create unnecessary obstacles to international trade. Now, what has to be kept in mind seriously, that whatever standards are adopted, and those are wide era of standards, like also including packaging, marking, labeling, so that they should not create unnecessary obstacle in the free trade. So basically the agreements that are included, and mainly here the technical barriers to trade, that is an agreement included, it should not be restrictive to the free trade. It should be facilitator of the free trade, although it has to take into consideration various risk factors. So basically it is how those risk factors can be eliminated or reduced, and then allowing the free movement of goods or free movement of trade. So desiring, however, to ensure that technical regulations and standards, including packaging, marking and labeling requirements and procedure for assessment of conformity with technical regulations and standards, do not create unnecessary obstacles to international trade. Recognizing that no country should be prevented from taking measures necessary to ensure the quality of its export or for the protection of human, animal or plant life or health. So it's both way. Firstly, that exporter country, they will come to know what standard they should meet when they are exporting the goods, and then the importing country, they can check whether those standards or the conditions have been fulfilled by the exporting country or not. And mainly the focus area is the protection of human, animal or plant life or health of the environment, or for prevention of deceptive practices at the level it considers appropriate, subject to the requirement that they are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or disguised restrictions on international trade, and are otherwise in accordance with the provisions of this agreement. Although this agreement enables the countries to impose restrictions, to set the standards, but then it is all subject to the conditions, like it was in the case of sanitary and phytosanitary measures, that such restrictions, they should not be arbitrary or unjustifiable or discriminatory, and mainly this discriminatory where the similar conditions are prevailing, or it should not be the restrictions imposed in the described form. Recognizing that no country should be prevented from taking measures necessary for the protection of its essential security interest. So that is a very, let's say, important area included in technical barriers to trade. Further, recognizing the contribution which international standardization can make to transfer of technology from developed to developing countries. Now, it's not only confined to the movement of goods, but it's this agreement also is taking into consideration the standardization of transfer technology, because sometimes the transfer technology from the exporting country to uh, let's say from the developed country to the developing country can again be a security threat, or it can be a security threat to another country. So since this area is covering the technical barriers, so it also covers such like challenges. Recognizing that developing countries may encounter special difficulties in formulation and application of technical rules, regulations, and standards and procedures for assessment of conformity with technical regulations and standards, and desiring to assist them in their endeavors in this regard. So, keeping in mind that the developing nations, they are at the different level of technical or technological expertise, so they may require some more time to understand those standards, so that assistance can be provided by the WTO bodies. Standards and regulation for digital and related technologies are commonly discussed in technical barriers to trade. So what we see today as artificial intelligence or other form of technology, the digital technology, as I mentioned, that it covers the transfer of technology, it covers the digital information, but what kind of information can be harmful for us or can be a security threat, all that is the present issues discussed under technical barriers to trade. Standards and regulation for digital and related technologies are commonly discussed in technical barrier to trade committee. Over the last few years, the committee has received an increasing number of notification of regulatory measures affecting a wide variety of digital issues ranging from autonomous vehicles and drones to 5G and artificial intelligence. More and more members are using committee, that is the committee under technical barriers to trade, to raise specific trade concerns with regulations of other members concerning artificial intelligence system, cyber security, use of QR codes, encryption requirements, privacy risk of data collected by vehicle sensors, and other issues. Consequently, at the end of 2021 committee, members agreed to hold 2022-2023 experience sharing discussions on the relation of technical barriers to trade agreement with the following digital topics. Firstly, the use of digital solutions for conformity assessment of goods obtained through e-commerce, possible impacts of technical barriers on trade, intangible digital products including artificial intelligence, and regulatory approaches on cyber security. So I thank you very much for being part to this discussion, and we further continue the discussion on technical barriers to trade in our next lectures, and I presently thank you for actively participating in this discussion. Thank you.
Hello, I am A.K. Sharma and I teach sociology in IIT Kanpur. I am trying to answer a simple question: how sociologists explain their facts. As you know that sociology was developed as a subject dealing with human behavior, but which would use the tools and techniques of science, mathematics, physics, chemistry. But this view that human behavior needs to be studied scientifically has been contradicted later on, and it was said that simply by relating one kind of facts with other kinds of facts, you cannot understand human behavior. To understand human behavior or to actually theorize about human behavior, you have to theorize the theories or motivations or meanings that people have in their mind in involving in a particular action. Now, using these two traditions, one tradition in which we relate one fact of society with other facts scientifically, and another tradition in which we try to develop second order constructs or theories that people have in their mind in acting in day to day life. They have produced two different traditions in sociology. One is called quantitative, another is called qualitative. Quantitative methodology uses scientific methods of conducting surveys, censuses, experiments, and then by using statistical methods, from simple method like arithmetic mean to sophisticated methods like logistic regression, we try to arrive at some inference. Qualitative tradition, qualitative methodology on the other hand uses ethnographic approach, and here the researcher attempts to become part of the community which he or she intends to study, because the assumption is that only by becoming part of the community, by living among the people whom you are studying, and by putting yourself in their shoes, by trying to understand things or their environment or their behavior or their culture or festivals or economic behavior or politics from their angle, from their perspective, how they feel, what understanding they carry in their mind, that only by understanding these things we can understand facts of society. Actually, in one of the latest works, World Bank, which uses a lot of statistics, has also talked about understanding mental models that people use in involving in behavior. Emile Durkheim long back said that sociology uses comparative method, and let me just give one example and then I will finish. Suppose I tell you that infant mortality rate in India is 40. What does it mean? It means nothing. But when you compare infant mortality of India today with Japan, and you find that Japan has 2 and India has 40, then you get disturbed. Then you start thinking, why is it that infant mortality in India is so high? And then you can also compare infant mortality of India with infant mortality of say Kenya or Mozambique or other countries, and you find that these countries have much higher infant mortality than India. And then you can create a hypothesis that perhaps economic development has something to do with infant mortality. Countries which are more developed, countries like Japan, they have low infant mortality. Countries like Mozambique or Kenya, which are less developed, have higher infant mortality. So, you have a connection. This is what sociology is about, connection between facts. So, by using census, surveys, by conducting field work, by using ethnographic methods, by using comparative methods, we arrive at sociological findings. Use of experimental method in sociology has been very less, but I learned that recently economists, which 10 years ago I could not see that economists will one day use experimental method, but today we find that economists are using lot of experimental methods to study human behavior. Now, this work may be done by economists, but the findings of their study can very well be called sociological studies. So, sociology tomorrow, I think that sociology tomorrow, in addition to using surveys and comparative methods, we will also be using experimental methods. Thank you.